Hi, everyone. We're going to give everybody another minute or so before we start to log in, and we will be starting shortly. Okay, well, I have 12:01, so I'd like to take a moment to welcome everyone today. Thank you for joining us. We are so excited to be here with our trusted partner, Andrea Chatfield, who supports clients through legal matters with integrity, transparency, and empathy. My name is Kim Rumler. I lead the HR and compensation teams here at KMA. Our 35-person team serves clients primarily across New England, supporting their HR, recruiting, and compensation needs. As we enter our 19th year, we continue to be passionate about the work we do in the organizations we serve. These free webinars are a way for us to support our clients, prospects, trusted partners, and the HR community that we are so grateful to be a part of. Just a few housekeeping items today. We will be emailing participants a copy of today's slides along with the HR credits, and all attendees are currently muted. We have a big group here, but if you have questions afterwards, please feel free to reach out directly to Andrea or me, and we'll be happy to help. So now I would like to take this time to introduce our presenter, Andrea Chatfield, who is an attorney with Sheehan, Phinney, Bass, and Green. She has a very impressive bio, which I'd like to share with you before she gets started. Andrea provides advice and guidance to employers on workplace risk management issues. She represents employers of all types and sizes before administrative agencies in matters of discrimination, whistleblower, unemployment, and wage disputes. She conducts in-house training for employers and also serves as an outside investigator for employers who have highly sensitive internal complaints of discrimination or harassment. She is also a frequent public speaker on employment law issues. Andrea is admitted to practice in New Hampshire and Massachusetts and is listed in Chambers USA as one of the leading employment lawyers in New Hampshire and best lawyers of America for employment law. Andrea received the 2022 Rye Perry Hero Award at the Granite State HR Conference. In addition, she's a member of the HR State Council of New Hampshire and was the government relations and legislative chair for 6 years. She also serves as the vice chair of the HR Healthcare Workforce Development Committee for the BIA of New Hampshire, and she has advocated for the HR community on employment-related legislative bills at the New Hampshire State House. So with that, Andrea, take it away.
Thanks, Kim. Good morning, I guess good afternoon, everyone, as of 2 minutes ago. I'm thrilled to be here with KMA, and we have a lot of material to cover in an hour. When we put the program together, I went, "Ooh, this is going to be robust." But there's a lot. There's so much going on, and I just want to reiterate that folks will be getting a copy of the slides at the end. There are links you'll see throughout my presentation embedded in the slides, and those will be live links for you because we try to keep this educational for you and give you some good educational resources. The other issue I just want to make you aware of is that we won't be taking questions during the hour, and as Kim mentioned, because there's so much to cover. But as Kim mentioned, you'll have my contact information in the slides, and you have Kim's contact information. You can reach out to either of us after the webinar is over. So let's begin. And putting together sort of a theme for today. In January, I always think of my Greek mythology class that I took in high school and learned about the two-faced god named Janus. Because Janus, which is what January is named after, by the way, is about transitions. It's about looking backwards. The older face is looking backwards, and the younger face is looking forwards. So it's about a time of transitions and new beginnings. And that's a really apt theme for January for HR folks, because we get to look back at what's been going on and how that's going to impact going forward in the future. So I always like to say that, our legal developments here are going to be, what we can expect in 2026 based on what we've seen in 2025. The other thing about Janus that I find interesting is that he's usually portrayed holding a key, and a key it was a symbol of safe harbor. And we're hoping that this program gives you keys to compliance and helps you navigate to a safe harbor from risk. But like I would never tell you to take advice from a two-faced God, I'm going to tell you that this presentation is not, don't take any of this as legal advice. It is educational, for educational purposes only. So I'm going to dive right into some big developments in New Hampshire law first, that affects any of you that have employees in New Hampshire. So New Hampshire did pass its own lactation breaks law, and it became effective July 1st of 2025. It applies to employers with 6 or more employees, and it's very similar to the federal lactation breaks law, but it's a little bit different. It applies to all your female employees, and it actually says that you have the obligation as the employer to provide reasonable break time. And reasonable break time is defined in the statute as 30 minutes for every 3 hours of work. But it goes on to say that the employer are always free to negotiate a different schedule than what is required under the law. The important thing is making sure you have a written policy that is compliant with what New Hampshire law requires, because New Hampshire does require you to have a written policy on lactation breaks that is disseminated to your employees. And if you were ever being audited by the New Hampshire Department of Labor on wage and hour issues, safety issues, or workers' comp issues, they're going to look to see if you have a lactation breaks policy. But the good news is that if you adopt a policy that's compliant for your New Hampshire employees, it will also be compliant with the federal law requirements. There is an undue hardship exception in our state law, but it has to be interpreted in conjunction with the Federal Pump Act and its definition of undue hardship. So if you have something that you think is preventing you from having an adequate space or being able to provide the break time, make sure you contact legal counsel to go through that with both the New Hampshire law and the federal law. Okay. The next big change in New Hampshire law was that in 2025, it enacted a bill that is providing up to 25 hours of leave time for new parents. And the law became effective January 26th. It applies to New Hampshire employers with 20 or more employees in New Hampshire. And it's basically any employee is eligible. There's no minimum threshold for, how long they have to have worked for you. But what the law requires is up to 25 hours of time off for qualifying medical appointments. And those types of medical appointments include for the employee's own postpartum or childbirth related medical appointments. But it also includes medical appointments that are for the child's pediatric medical appointments. And this is all within the first year of the child's birth or adoption. So it does apply to adoptive parents for that purpose. It also applies to men and women because fathers can be taking the baby or the child to the pediatric appointment. So it's within that first year. It provides them with that time off. If both the parents work for the employer, you can combine it for a total of 25 hours. A little bit about how it works. The time can be, the law says that you must allow the employee to use accrued vacation or PTO time during this time, or if your sick time allows them to use it for medical appointments, they have to be allowed to use that. Whether or not you can require they use it is dependent upon how your own paid time off policies are written. Some are written to say that any absence, we're going to apply your PTO. If that is the case, then it would apply to this. So you want to make sure that you're coordinating it with that. But for salaried employees, keep in mind that in salaried employees, most laws do not allow you to deduct or dock a person's salary if it's for a partial day absence. Like they're going to take the child to a pediatrician's appointment in the morning, they'll be back in the afternoon. you can have them apply their PTO. That's totally fine. But if they have no applicable PTO time accrued, then you still have to pay them as a salaried employee under both state and federal laws. So that's something to keep in mind. But for hourly people or non-exempt employees, it can be unpaid time unless they want to use their time off. Other important information, it does protect the person's job. So if they leave in the morning to take the kid to a doctor's appointment, they come back in the afternoon, yes, they have to be reinstated to their original job. That's a no-brainer. But also you want to be careful too. You shouldn't be discriminating against them by saying, hey, you're taking too much time off from medical appointments. But a couple of the other things is the employee is required to provide reasonable advance notice of need to take the time off. And that's good. There is a bill in the New Hampshire legislature right now that would change that to say they have to apply, they have to provide at least 15 days advance notice. Even the BIA, which is very business oriented and friendly, is saying that's not going to be practical for medical appointments like this. So we don't think that bill's going to go anywhere, but reasonable advance notice is what they should be giving. Also that they have an obligation to make efforts to schedule it then in a time that doesn't unduly disrupt the employer's operations. But there's one other piece that we wanted to make sure was in there is your ability, is the employer's ability to request and require the employee provide you with some sort of documentation to verify that the time off was used for a qualifying medical appointment, like a doctor's note or a note from the practice to say, yes, they had this appointment today. Okay, the other big news in New Hampshire that you should be aware of is a new law that really surprised all of us because it snuck through the legislature last year with a lot of HR people and employment law people not even knowing it was happening. But it is a law that provides leave time and employment protections for military spouses. So a lot of you are already familiar with USERRA, the federal law that requires you to provide leave of absence for employees in order for them to perform their military service. So this law applies to the spouses of the military members who are your employees. The employees who are spouses are the individuals who are spouses that are your employees as well. And what it says is that basically, first of all, you can't discriminate against an employee because their spouse has been called up on an involuntary mobilization. And the employee has a right to take a leave of absence and be reemployed because of that, their spouse's involuntary mobilization. An involuntary mobilization, by the way, means that the spouse is being called up to active military duty due to a national or state declaration of an emergency or declaration of war or similar type of military action. So it's not for things like military training or the annual, reserves training. But what it says is that if the employee needs to take a leave of absence, they have to let you know within 30 days of their spouse getting the official notice of mobilization. The employer has to respond with a written acknowledgement of the notice of deployment and explicitly confirm adherence to this new law. It's a little bit of an odd requirement, so that's something to pay attention to. The leave of absence can be unpaid, and no benefits or accrual of benefits need to be provided. The duration of the leave is a little unclear. The law says that the intent is to provide employment protections for up to 1 year and a day, but then it also goes on to talk about that the employee has reemployment rights similar to the duration of the spouse's reemployment rights under USERRA. So it's a little confusing. But if you have an employee who says my spouse is being called up because of a declaration of war, because of a state of emergency, I need time off, then absolutely you need to work with them and follow this policy. And the duration of the leave, I would say, talk to legal counsel or talk to the New Hampshire Department of Labor, which is the agency that will be enforcing this law. And so that's something to keep in mind. I'm also going to mention that, again, reemployment means that you reinstate them at the end of the leave to a position of like seniority, status, and pay to which they're qualified. It does have a kind of undue hardship exception, which says you don't have to reemploy them if circumstances have so changed as to make reemployment impossible or unreasonable. And that's similar to the same standard as in USERRA. Complaints are filed with the New Hampshire Department of Labor, and they can award back pay and some other types of damages. So definitely, one of the things I'm going to urge you to do as takeaways is, first of all, updating your policies for time off, right? Cover the military spouse leave. If you have, this is a big caveat I didn't mention at the beginning, it only applies to employers that have 50 or more employees in New Hampshire. So obviously it's for larger employers. But if you have that, then you need to update your leave of absence policies to include this policy. If you have 20 or more employees in New Hampshire, you also want to update your paid time off policies to include that 24 hours of time off to attend qualifying medical appointments. But then you also need to be educating your managers on how to address these types of situations and requests for time off in these circumstances. They need to be educated to know that these are different types of circumstances that may require job protection and leave protection. Okay. Now, here we get into a lot of nitty-gritty issues for multi-state employers. As a lot of you probably know, if you are a multi-state employer, there are a lot of states coming up with either paid sick leave laws or paid earned time laws. And here I give you what is currently the list of states that do have laws requiring employers to provide these types of paid time off benefits. And it's basically up to 20 at the moment of states, but there's also a lot of numerous cities, towns, and counties that have their own laws. So if you have people in major cities like, excuse me, Chicago or Philadelphia or most cities in California, then you're going to need to make sure that you're in compliance with those laws. One change that came up last, I think maybe in late 2024, the paid sick time laws typically have specific reasons a person can use the paid sick leave that they're accruing under the law. And in Massachusetts, it recently was amended to include not only the traditional reasons, sick time that they need for appointments, sick time that they need, sick time for their own health condition, their family's health condition, to deal with issues of domestic violence. But also they added that an employee in Massachusetts can also use their paid sick leave to address their needs, physical and mental health needs, due to a pregnancy loss, failed adoption, failed reproduction, or failed surrogacy. And then we have Maine. And Kim and I were talking right before this. I've already started getting questions about this. She's been getting questions about it. Maine made a big change to their earned paid leave law, which applies to employers who have 10 or more employees in Maine. And it's basically different from the other paid sick leave laws, as we all know, because it's earned time. It can be used for any reason. But this was a big change. Prior to September of 25, if you had a policy that front-loaded the paid time off, that in other words, rather than accruing the up to 40 hours or accruing your PTO by the time they work, if you give them the allowance at the beginning of the year, that's called front-loading, you did not have to let them carry over any unused accrued time. So unfortunately, they changed that law. And starting September of 25, basically employers have to allow their employees to carry over accrued and unused hours of earned paid leave from the previous year. And earned paid leave means that 40 hours of leave that the law requires the employees to be able to accrue. So you have to allow, even if you front load time on January 1st for the 2026, if they have up to 40 hours of accrued unpaid, earned paid leave from 2025, they get to carry that over. So there's been a lot of questions about that. And also the carryover cannot reduce the accrual of the 40 hours of earned paid leave in 2026 that they would get. Now, our understanding, and from at least one conversation I've had with the Maine Department of Labor, is that you can limit the carryover to 40 hours because that's what the law requires you to allow people to have is the 40 hours. I also have had the question of, well, can we just pay it out as opposed to carrying it over? And the answer that the Department of Labor has given is to say, based on the way the law is written, you have to allow them to carry it over. You can't require that it be paid out. You can offer to pay it out, but you can't require that that up to 40 hours will be paid out at the end of the year. Offering the employee the option of either carrying it over or paying it out can actually incur certain problems under tax laws because they're considered to have constructive receipt of the time in 2025 because they have the ability to choose either getting it paid or carrying it over, and therefore may have a tax liability in 2025, even if they carry the time over. That's only if you give them the option to pay it out in 2025. Confusing as hell, I know. But just know that if you have Maine employees, really pay attention. Talk to the Department of Labor in Maine. They've been pretty responsive. They do a lot of classes. I can just tell you that I know that this is going to be a big change. And if you're trying to use your regular PTO policy to comply with Maine law, let's say you give PTO of up to 80 hours a year, and you think, okay, I've tried to calibrate it so that it complies with Maine law, then that's fine too. But it gets harder if you have employees in other states that have these paid sick leave laws and paid time off laws. It's getting harder and harder to come up with a universal PTO policy that will comply with every state. So definitely work with legal counsel if that is what you're trying to accomplish. Okay, takeaways. So you make sure you're looking at your paid earned leave policy for Maine employees to ensure that they can carry over the 40 hours or up to the 40 hours. And the other thing to keep in mind is if you have a general PTO policy that you apply to Maine employees and other employees in other states, make sure it still also complies with this Maine law requirement of carryover, even if you do front load the time. Okay, Maine paid family medical leave. This is a law that, as you know, it applies to employees who work in Maine, even if the employer is outside of Maine. And it applies even if you have one employee, as you probably know. Starting January 1st, you had to make contributions. You had to register the employee in the state of Maine and make contributions. Hopefully, you've started doing that. May 1st is when benefits availability will begin. There was a qualification that if the fund was found not to be solvent, they may delay that start of benefits to August 1st. But Kim very nicely noticed that the Department of Labor just came out with an announcement today that says that they will be solvent, or they think they'll be solvent, and that benefits will become available starting May 1st. So that's fresh off the wire feed there. So then the one thing I wanted to point out on the Maine statute is that there was a recent amendment to that statute, also effective September 24th, 2025, that talked about that intermittent leave has to be taken in increments of not less than one workday, unless the employer and employee decide or agree otherwise. But even if they do agree to have it in less than 1 day increments, it can be no smaller than 1 hour increments. It also had an interesting change that I had not seen before, in that a company or an employer who is buying or is succeeding to a Maine employer that has Maine employees is going to be liable for any premium contributions, penalties, or assessments that the selling employer did not pay to the state under this paid medical leave law. So that means a couple of things. Takeaways: look at your written policy for eligible Maine employees. Make sure that they're duly registered, that you're paying the contributions compliant with Maine law, but also address whether intermittent leave can be taken in 1 hour or increments or only 1 day increments. The other thing too, and this will put you in good stead with people like your CEO and CFO, if you know that your company or your organization is looking to purchase an entity that has Maine employees, make sure you alert them to this issue that the buying company couldn't be liable if the selling company has not been paying the contributions to the main paid FMLA leave law. And that therefore that's part of the due diligence is that they should be asking that specific question of the company that they're looking to buy. Here's a quick list of the current states that have mandatory PFML. We're up to 14 now, as you can see. Maryland comes online in 2027, but also there's 2 states that have voluntary PFML programs. That's New Hampshire and Vermont. So again, it's quite the multi-state patchwork type of area of law. Okay, so that covers paid time off. Pay. We're still talking about pay, but now we're talking about pay transparency. And this area of law is something that's been developing over time. And I'll explain a little bit of the history of it first. And it started with, it's really kind of evolved in that it started with restricting employers' ability to stop employees from talking about their pay. So you can't prohibit discussions among employees. And that is something that we've seen on the national level with the National Labor Relations Act, but we're seeing it in pay transparency laws that states are passing. So that was sort of the less burdensome requirement. Then the law evolved. And keep in mind, the goal is to try to close that wage gap between male and female or white, Caucasian people and people of color. It's trying to close that wage gap by making information more available. So that's the first less restrictive requirement we've seen in pay transparency laws. Then pay transparency laws, that wasn't being enough. That wasn't seen as enough. So then you saw laws being passed that said employers cannot ask about the prior history of a salary or hourly pay that an applicant had in negotiating a pay rate for a new job. So when an applicant applies, you can't ask about what was your prior hourly rate, what was your prior salary rate. So that was a little bit more burdensome. But then they found that still wasn't enough. And what states started to do then was really tighten up the pay transparency laws to now include an obligation that the employers must disclose the pay ranges for job vacancies in their job postings, both to applicants outside the organization and to employees who are applying internally for job vacancies. So as you can see, the burden has gotten bigger and bigger, but again, it's trying to find where is it going to be more effective. At what point will it be effective enough to close the pay gap? And some states like Colorado that have had these laws in place are seeing an improvement in closing that wage gap based on these types of laws. So what's going on around the country? Again, here we are with the patchwork quilt of state laws. We have at least 24 states, and it's growing because there was 17 states in 2023 that have pay transparency laws of some type. Most of them just will say that that employees can freely discuss their pay with each other or anyone outside without fear of retaliation. And some do also prohibit asking for salary histories. 16 states, including some municipalities, also have the laws that have the most restriction, which is that employers must disclose pay ranges for job vacancies. So Mass, Connecticut, Vermont have that higher requirement that you have to disclose pay rates and job vacancies. We'll talk about Mass in a minute. Rhode Island requires employers to disclose it upon request by applicants. New Hampshire, not one of these states so far. But there is a bill to make New Hampshire one of these states. So we're keeping an eye on that in our legislature right now. So as this trend grows, here's a couple of, I just want to highlight for you some of the newer requirements. Massachusetts, effective October 29th, as many of you may know if you have Massachusetts employees, it covers employers that have 25 or more employees in Massachusetts, and you must disclose the pay range in the job postings that in good faith you expect would apply to the job that is being advertised. And keep in mind that the law is applied to job postings for jobs where the work would be done in Massachusetts, which somewhat helpful, but somewhat not, because so many of us now know, so many businesses nowadays are putting postings on LinkedIn for that, that especially if remote workers can apply from any state. So we're waiting to see how those will be handled. But the law does say that it applies to job postings for work done to be done in Massachusetts. There is some the violations under the mass law. It is a graduated, it's a progressive structure. But what's nice is that until October 29th of 2027, the Attorney General's office in Mass said that covered employers, if you will have, basically, you're going to get a notice to cure letter. If they find one of your job postings doesn't have the pay ranges, they're going to send you a notice to cure letter. You have 2 business days to fix the defect and not be penalized. So that's at least trying to ease people into the enforcement of this. The other interesting that Mass does goes a step further, and again, not something I've seen often, is that it requires companies that have 100 or more employees in Massachusetts and that are subject to filing annual EEO-1 reports, that you also must file a copy of your most recent EEO-1 report with the state. This reporting requirement started last February 25, February 1st. The next reporting deadline is going to be February 1st of this year. There is an FAQs on the state website, and there I give you a, here we go. I give you the link to those FAQs if you have questions, and then there's a link to how to get to the filing portal with instructions if you've not already started doing this. There are some different timeframes. If you have local unions who file EEO-3s, state and local governments file EEO-4s, and elementary and secondary staff, employers with those types of staff have EEO-5. So there's different states, there's different timeframe requirements on that, but that's all explained in the FAQs. So something to keep in mind. Vermont likewise recently passed a pay transparency law that became effective July 31st, 2025. And that covers employers that have 5 or more employees, with at least one of whom works in Vermont. So this could apply to small companies, like say a company in New Hampshire that has 10 employees, but if you have a couple that work in Vermont, this law would apply to you. And again, it's to cover, it covers job ads that are for openings that will be either physically located in Vermont or remote jobs that will be performed in Vermont. And it's interesting, what I've seen in all these laws basically is, what do they mean by what is the pay range I need to disclose? And it's usually defined as minimum and maximum annual salary or hourly range that the employer in good faith expects that would be paid for that job. So you see that word good faith a lot. And that is a concept that as these laws get challenged, perhaps we might see more guidance on what we mean by good faith. But the Vermont also has published a nice final guidance, and I give you a link to that at the bottom of this that hopefully will help you in that situation. Okay. New Hampshire, however, well, the pay transparency trend grows, but not so much in New Hampshire. In New Hampshire, we have one law there, RSA 275-41B, that only prohibits employers from restraining employees from disclosing their wage information to anyone, or from disciplining or discriminating against employers for disclosing their wages. And of course, there's an exception that if the employee's job requires them to have access to confidential information like wage rates, they can be, that's considered confidential company information, that you can restrain them from disclosing that. But in New Hampshire, you can still ask for the pay rate history of the job applicants, and you are not required to disclose pay ranges in your job postings. One thing I do want to bring to your attention is that the laws that restrain employers from prohibiting employees from disclosing their wage information to anyone, keep in mind that's all their wages. We had a client that wanted to implement a bonus program or a bonus benefit for only certain employees and wanted the employees to keep that confidential. But in looking at the applicable state law language, you could not have an agreement that you require an employee to keep their compensation information confidential. So sometimes it depends upon how the law is written, but keep in mind that when they talk about wage information, they might be talking about all of the employees' compensation. Okay, so some takeaways. One thing I will say that if you do have to disclose the pay ranges because you're advertising in certain states, let's say you have your nationwide advertising for a job that could be done anywhere, you might consider just disclosing the pay range for all those types of job postings, so that you won't run into trouble with states that require it. But also what we're finding is that applicants a lot of times may choose not to apply for a position unless the pay range is disclosed. The other thing I think that's important here is that identify your pay ranges first and foremost. Make sure that that you're following a consistent protocol, but also even if it's not required in where you're recruiting, hiring managers should really be prepared to discuss what the pay ranges are, because even if you're not required to disclose it, it's still information that the applicant or the employee is asking for it. It's important to them. And if you want them to still consider and be in the running, you're going to need to have your managers be able to have these discussions in a knowledgeable fashion. Okay, and then if you do have, if you're trying to come up with some guidelines, I point you to a couple of links there. The New York Pay Transparency Fact Sheet. They have a very aggressive citywide requirement or statewide requirement, and the California FAQs. They do have some very good guidance on what you should be doing in order to comply with their pay transparency laws. And take 1 minute so we all can take a breath. And that kind of rounds up some stuff about pay transparency and paid leave laws. Next thing I want to cover is EEOC. There's been a lot going on there this past year, and I'm going to talk a little bit about where we think they're going. That Janice looking forward now. Where do we think they're going? So in November, their acting chair, Andrea Lucas, became their permanent chair of the EEOC's commission. And as you may know, that in January, 2 of the Democratic commissioners were removed. So they finally have a quorum of commissioners, meaning they can now revise their guidances, revamp their regulations. And what Chair Lucas has said is that her priorities for the EEOC in the coming years is going to be really focused on eliminating unlawful DEI-motivated race and sex discrimination, as well as defending and protecting American workers from anti-American national origin discrimination, and defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces at work, and protecting workers from religious bias and harassment, including anti-Semitism. Now, it would seem that they're just going to focus on those particular areas, but keep in mind that the law, the statute has not changed, that national origin discrimination is still illegal discrimination, whether it's anti-American, anti-Hispanic, anti-other countries, it's still discrimination. And the same for religious bias and harassment. It's not just anti-Semitism. Yes, that is definitely illegal harassment and bias, but also any type of, anti-religious laws. So what the EEOC did is started to give us some guidance on what they mean. And what they did is they published 2 guidances recently in March. What to do if you experience discrimination related to DEI at work, and what you should know about DEI-related discrimination at work. Now, what's interesting is that these guidances are directed to employees. But at the same time, it's good reading for employers, because it will be useful to read these to say, what is it that would be considered under the EEOC scrutiny? And some examples of what they consider to be DEI related discrimination. We're still not quite sure what it means, but it talks about disparate treatment in hiring, giving a preference to perhaps one protected status, legally protected status over another, access or exclusion from leadership development programs, access to internships, mentoring relationships, summer associate programs that back in the early summer or early spring, the EEOC was looking to a lot of the bigger size law firms that had summer associate programs. They hire law students to be summer associates, and they were under DEI initiatives focusing on hiring more people of color, females, and those types of hiring practices and recruiting practices are going to be coming under their scrutiny. The other thing to mention is that, we need to really make sure that we're training managers involved in hiring to not indicate a favoritism towards one type of legally protected status or another. And it does require reviewing development programs, resource groups, and training programs in light of these guidances that I gave you links to. But also remember too, it's not, even though the EEOC has said that depending upon facts, an employee might be able to claim that a diversity or DEI related training created a hostile working environment. Even though they've said that, that does not mean you should be shying away from still doing your anti-harassment, anti-discrimination trainings. Those are still really important. And as long as you're making sure that you're focusing on all types of legally protected statuses, and that I think a lot of times this means that you can still focus on really important aspects of anti-harassment training, like civility in the workplace, respect in the workplace for all. And also be careful and be sensitive to anything that may trigger someone as far as feeling that it's a hostile work environment. But you can still definitely and should still continue your anti-harassment trainings. The EEOC's focus on national origin discrimination also talks about, they've updated their guidance to make it clear that Title VII protects all employees, that national origin discrimination can include preferring foreign workers over American workers, so you need to be careful of that, and that they've also updated their website regarding national origin discrimination, and I give you a link there, which can be helpful and good useful reading for you. Really quickly, I'm going to talk about the fact that EEOC made another major announcement in September about that they will no longer, at this point, investigate or pursue at the EEOC level claims of disparate impact discrimination. Now, disparate impact discrimination means that you may have a policy that's neutral on its face, but has a disparate impact or disproportionate impact on a protected legal status. For example, you might have a policy, the most common type is you have a policy that says we will not hire anybody that has a criminal background. And that has been seen historically to have a disparate impact on people of color, and people with disabilities, especially developmental disabilities. So it has a disparate impact. The EEOC is saying we're not going to investigate those types of claims anymore. Only disparate treatment claims, meaning something that is targeted to a particular protected status. But that doesn't mean that those claims go away, because an employee will be able to still pursue those types of claims in court. And keep in mind, other state fair employment agencies like the Human Rights Commission, Mass Commission Against Discrimination, they may still very well still pursue and investigate those types of claims. The other interesting development in EEOC law last year was a Supreme Court case called Ames versus Ohio Department of Youth Services. This came out in June of 2025. And this was about reverse discrimination, which kind of ties into what the EEOC is talking about as far as the types of things they're going after. Reverse discrimination means that somebody is treated differently or discriminated against because they're in a majority status. Male is a majority status to female, Caucasian people who are white versus people of color. An American, it would be a majority status versus somebody born outside of this country having a different national origin. And in this particular case with Ames, it involved a heterosexual female who was denied a promotion and was replaced by a less qualified gay person, by a gay woman, by the hiring manager, who was also a gay woman. And later, when that heterosexual woman was terminated, she was replaced by a gay man. So she was trying to claim reverse discrimination here. I'm being discriminated against because I'm straight. And the lower courts had said, well, when we have reverse discrimination claims like this, we usually have, the employee has to really prove a different standard to show that there was some unusual circumstances, that this employer was acting in a manner that was unusual in how they discriminate. And the Supreme Court rejected that standard and said, no, the reverse discrimination claims are discrimination claims, and they're going to basically be proven based on the same evidentiary standard as any other type of discrimination claim. So that's what that means. But just to let you know that that could end up by really increasing the types of reverse discrimination claims we start seeing. And in order to avoid it, what does it mean? Making sure you're not discriminating against anyone based on any type of the legally protected statuses, no matter their national origin, no matter their gender, no matter their sexual orientation. And to ensure that your programs are not excluding anyone, but on also, again, harassment training should still focus on that civility and on inclusion of all. Okay, so now we're turning to AI in hiring. AI is a topic that I'm sure all of you are struggling with, dealing with, wrestling with, and certainly is something that is being talked about. As a matter of fact, that looking into 2026 and beyond, everything you read says that two top priorities for businesses and CEOs is going to be adoption of AI and attracting top talent. And I can tell you, just this morning, I was listening to the news, and AI is being talked a lot about at the Davos Economic Summit right now, along with other things. But they're definitely all talking about AI, the good and the bad of AI. Some saying it's, the destruction of the human race. Others are talking about it's going to be the best thing to happen to the human race. But I'm sure every business has to decide what it's going to do with AI. So for HR professionals, it means adopting AI as a way of attracting top talent. What does that mean? Well, one of the things you're going to need to do is really make sure that you're really capturing what's the value from the use of the AI. Why do I want to use it? And is it giving me value added recruitment practices? And that's going to be a major focus. And how do we measure that? And then in addition to that, as AI and the use of AI is exploding, so too are laws and regulations by states that impose obligations on employers in their use of AI in employment decisions. So what are those general themes of those? Unfortunately, in the 10 to 15 minutes we have here, I don't have time to go through all the details of it, but what are the general themes? I can't really go into the details, but I'm going to go into some of the general themes that we're seeing in these state laws. And they can include a combination of some or all of these. The big one is that you have to make sure as the employer that whatever AI product you're using, that you make sure that it's not got algorithmic discrimination. I can say it in my head, I can't say it out loud. But so these laws prohibit algorithmic discrimination, meaning that there's something in the algorithm that is giving a preference to certain or discounting people based on a status, either a disability or a mental health issue, or the age, which is something that we have seen in some of the legal cases that have come out. These laws on AI and recruiting by the states also require employers to perform risk assessments to mitigate the risks of algorithmic discrimination. So that's going to be something that you have to understand if you're recruiting in a particular state that has these laws, then what does that risk assessment look like? Making sure that some of these laws also require employers to provide candidates and employees with adequate notice of the use of AI in the employment decision process. And sometimes they'll even say even the type of AI product that you're using and how you're using it. And then also some of those states also provide a right of or an opt-out or appeal for employees if there's an adverse decision. So right now, what I did here is give you a sample of what I find to be the most significant laws. And again, while California is one that does put a lot of burden on employers, it also provides a lot of effective guidance and regulations, or helpful guidance and regulations. And they've just come out with some privacy regulations effective January 1st that you should take a look at if you are recruiting in California. Colorado now has statutes on artificial intelligence, and they're working on regulations, but this gives you some guidance. Illinois has developed a couple of things. They have the statutes, and then they also have some draft rules on AI and employment that right now they're just draft rules, but they give you an indication of what they're looking for employers to be able to do. And then New York City has FAQs on what they call automated employment decision tools, basically AI in recruiting. And they've probably had the most well-known guidance on this since they started this a couple of years ago. So I would urge you to take a look at those, especially even if maybe you don't have, you're not in a state that requires these obligations or restrictions on the use of AI. Keep in mind, excuse me, keep in mind, many other states have introduced similar legislative bills, and those could be coming into play. They may not. One thing I did want to bring your attention to is that in December, last month on 2025, the president signed a federal executive order that would stop states and localities from enacting laws restricting AI and establish a uniform, minimally burdensome national standard. The idea of being able to establish a uniform national standard is something we need in so many areas of the law, as this 1 hour has hopefully illustrated. But whether or not the executive order can officially or have any binding effect to stop states from enacting their own laws remains to be seen. It'll probably be under legal challenge, but I think it's going to slow down states from enacting any of these laws. But here's what I suggest. Keep track of these legal developments. They're important, and they could change in a heartbeat. But if you are going to use AI products, even if you're not in a state where it's going to require stuff, be sure that you can vet them and vet the vendors of these AI products to ensure that there are safeguards to avoid algorithmic discrimination, because it still could be discrimination under your state discrimination laws. So you want to make sure that they have some safeguards in place for that. Take time to assess the effectiveness and value of the product. And not only in terms of efficiency, I can get through 1,000 resumes in 2 minutes, but really, is the AI product being effective in identifying for you the top talent and the viable candidates in that pool of applicants? And is it giving you really good, useful quality information about how to assess them? And always remember, AI should be a tool, not the decision maker. You are the decision maker. Humans need to be the final decision makers. It can only be a tool for helping you organize and sift through these types of applicant pools. But I also, before I leave AI as a topic, I also wanted to also mention to you that you have to think about AI in your workplace. And having a policy on the use of AI in the workplace is becoming more and more something that employee handbooks should really include. And so what I've done here is give you a short checklist of what are the major points that your AI in the workplace policy should cover. First, it should talk about permitted uses. Again, reiterating that it's a tool, doesn't replace decision making. It shouldn't create the final product, that anything it does, any output from AI, if it's a report, if it's a memo, it's an email, it needs to be reviewed by human eyes. And also, what are the security measures that your IT people need to have in place? Making sure that if people are going to use AI, that there's prior approval required. Understanding open platform versus private closed systems. And this is going to be important when it comes to protecting confidential information. Open platform systems, if you put a query into it, like a ChatGPT takes that query and that information and uses it in learning more. And unfortunately, what we have found that sometimes employees are inadvertently putting in their queries confidential information, identifying specific customers or business plans or marketing information. And so you need to be really careful about what they're putting in their queries, and also what else is necessary to protect company or client confidential information, and whether you're using an open platform or what perhaps private closed platforms or systems are that you would approve for use. Best practices, as well as the risks that come with using AI, and knowing that AI can be hallucinogenic at times and come up with false things and false facts. So it's important that you have policies about that. The last topic I want to cover today is, as I've told you, I've always been talking about that state laws create this patchwork quilt, and that is also true of non-competes and non-solicitation agreements. What do I mean by non-competes and non-solicitation agreements? So first of all, these are restrictions that you may have employees sign up for that apply both during employment and for a period of time after employment. And a non-compete, that type of restriction means that you're asking the employee to agree. I won't compete against my employer while employed, and for a period of time after I leave employment, I won't work for a competitor, start my own competing business. I won't engage in competitive activities against my employer. That's a non-compete. That's seen as the strongest type of restriction you can put on someone. There's the next level of restriction is what we call a non-solicitation agreement. And that's where you're getting the employee to agree both during employment and for a period after employment that they won't solicit your customers or your clients for work that is similar to what you're providing. So if I leave employment for the next 2 years, I won't solicit the customers that I knew about or any customers of my employer. You can also, a non-solicit can also apply to not soliciting employees, that for I won't solicit my fellow employees to leave the employer, to leave the company, and come work with me or hire them away from the company. That's another level of restriction, less restrictive than a non-compete, because it's really focusing on soliciting customers and clients or employees. But then the other level of important restriction is what we call a non-disclosure agreement, which defines what we consider to be company confidential information or client confidential information, customer confidential information, and that the employee agrees not to disclose or use that information when employment ends for any reason, as long as that information is confidential. So that's what I mean by those terms. So what we're seeing in various states is that there are restrictions on employers for being able to use these types of agreements. And the themes, again, that we're seeing are banning non-competes for what we call low-wage earners. In New Hampshire right now, we do have a law that bans non-competes and probably non-solicitations on any employee, for any employee who makes 2 times the federal minimum wage. So any employee who's making, $14.50 an hour or less, you cannot have a non-compete or non-solicitation. There is a bill in the New Hampshire legislature to change that to employees who are making at least 5 times federal minimum wage, which brings it up to basically $75,000 a year. So anyone making $75,000 a year or less could not have a non-compete or non-solicitation, would be unenforceable. That's a bill being proposed. Other states have various different levels. Some say you can't have a non-compete with anyone who is an hourly paid employee. Some say you can't have a non-compete with employees who are making less than $100,000, but you can have a non-solicit for employees who are making less than or not less than 70,000. I mean, it's all different rates, so you have to really pay attention to that. Another theme or another approach we see is basically saying no non-compete and or non-solicitations on all employees, or perhaps restrictions on non-solicitations of customers and or employees, or occupational specific bans on non-competes. In New Hampshire, you cannot have a non-compete that has a geographical limit, for on physicians and nurse practitioners. And other states have other types of specific occupation-specific restrictions. There's also restrictions we're seeing on the choice of law. Like if you have an agreement that's a non-compete or a non-solicitation, first it's got to meet certain criteria. But even then, the choice of law where we say that any disputes under this contract will be, litigated in the, New Hampshire courts and under New Hampshire law. But some states are saying, no, you can't have that. You can't choose what law you're going to have. If the work is being done in a specific state, you have to use that state's law. Massachusetts and California are two states that have that type of restriction. So be careful of that. The good news is that protection, any agreement that is for the protection of confidential information that restricts your employees from disclosing confidential information when they leave or taking any confidential information, any protections about intellectual property are usually excluded from these laws. Those types of agreements are generally pretty much always enforceable if they're written correctly. Trade secret laws. Every state usually has a law that protects your trade secrets, which is really certain information that you protect and call a trade secret. That doesn't necessarily mean all your confidential information. Like you might have a trade secret in a particular manufacturing process or a service process, but that's not your only confidential information. Your other types of confidential information could be your internal marketing programs, your financial information, your client, your customer information and what they've ordered and the relationship with them and their contact information. So that's why it's important to have an agreement that defines confidential information more broadly. Okay. All right, non-competes again. In states where they're still enforceable, there is a very robust body of case law because every state will say that even if it's enforceable in the state, or even if we don't have a statute that prohibits them in some way, courts are still going to really always scrutinize to ensure that non-compete restrictions are reasonable. So every time I hear clients say to me, hey, I've heard that I can have a non-compete, but it's not worth the paper it's written on. Is that true? It depends. Hey, I have a non-compete that I got off the internet or I got from a friend that they've enforced this in the past. It should be fine for me to use, right? Nope, it depends. It's all very, very fact-specific analysis that a court will go through because they want to really look at, are you restricting the employee in the most narrow way possible, using the least amount of restriction necessary to protect your interests? What's absolutely necessary for you to protect your legitimate business interests? Is the geographical restriction you have reasonable? Like if a person was just a salesperson in one territory, to prohibit that person from competing against you in all of the country would be an unreasonable geographic restriction. It really looks at the scope of the employee's work, the authority that the employee had, their area of work, and also duration restrictions. A 5-year post-employment 5-year restriction is probably way too much for most types of non-competes or non-solicitations. Usually a year is seen as pretty reasonable. But also keep in mind that if the employee is considered to be a low-wage person, and this would really, or any type of person that the restriction is so broad, it would prohibit them from being able to find work in that industry or field, it could be considered unreasonable. So again, these are types of agreements that you really have to pay attention to and make sure that you're drafting them with legal counsel. So that's my takeaways on that is focus a lot on your confidential information and protecting that and making sure that you're using effective employee agreements for these types of restrictions. And I will turn it back over to Kim.
Thank you, Andrea. That was wonderful. A ton of really good, interesting, useful information. So thank you so much for joining us today and presenting. I know that was a lot. And I'd just like to thank everyone for coming today. And just a reminder, we will be sending copies of the slides to you with the HR credit information. If you have any questions, don't hesitate to reach out to Andrea or myself. And I hope everyone has a wonderful day. Thank you all again.
Bye-bye.
Take care.